in 10 tenants remain in default with their landlords. This is not nearly as bad as where we bottomed out in the middle of lockdown, where 50%, 1 in 2 tenants, were unable to pay their rental, their commercial rental landlords. Business rescue has become an important topic to talk about today because so many businesses are struggling, and until the South African economy starts to recover, it's a challenge that we're going to be facing. Businesses closing, businesses going into business rescue, businesses going into liquidation. In studio with me today, I've brought Peter Mennen, our head of legal, and Ofentse to come and talk to us about the business rescue process. The better we understand the process, the better we can strategize as landlords in how to protect our own interests throughout the process. Also in studio today is Greg Mason. He's also one of our TPN in-house legal counsels, and he's going to be facilitating the Q&A. So just to set up today's session, it's going to be an hour long as usual. I'm going to hand over to Peter and Ofentse in a moment, and they're going to take us through 15 minutes or so discussion around the legal aspects of business rescue. Then I'm going to ask Peter to join us or to join me here, and we're going to look at the different terms in your documentation, your leases, your sureties, your mandates, etc., and how to protect yourself during the business rescue process. So how to set yourself up right at the beginning of the documentation period, at the documentation time. In order to facilitate the questions and answers, please do log yourself into your YouTube. That'll open up the chat on the right-hand side of the screen, and then you can ask your questions, and Greg from legal, Brian from help desk will be answering some of those questions live with us. Greg will then also facilitate asking those questions to Peter during the session, and he'll be able to answer them live for you. The last 15 minutes we're going to leave for general Q&A. So we're going to some of the questions, Greg will interrupt Peter and we'll have a little bit of a debate, and then some of the questions we'll leave till the end in the last 15 minutes, just depending on the nature of those questions that you are asking. If the screen does seem a little blurry to you, what you need to do, go down to, there's a cog on the bottom right hand side of the video. Click on the cog, click on quality, and then change your quality either to auto or to at least 720p. Then right at the end, folks, we're going to do our Q&A. We're going to have feedback forms. Please do click on the feedback link that Greg will post in the chat in the last 15 minutes, and that'll allow you to submit your feedback to us. Very useful for us in order to create content, the timings, where you feel that we could improve, and what you liked. But right now, Peter, Ofentse, over to you. Thank you.
Thank you very much, Michelle. With me today in studio again is Ofentse Motshudi from Morrison. We will be discussing business rescue, a very topical subject in South Africa at the moment. Just having a look at CIPC's data, 233 companies entered into business rescue proceedings during April to October of last year. The likes of which include Stir Chemical, Edcon, Comair, Pumela Gaming and Leisure, and SAA. Obviously, Ofentse, this is quite a difficult question to start off with, so I do apologize. But in a nutshell, what is business rescue proceedings and how does it relate to liquidation?
Yes. So in a nutshell, Peter, the distinction between business rescue and liquidation is with liquidation proceedings, the lifespan of the company is coming to an end. In other words, the company is being wound down, and after the proceedings have been completed, the company will be no more. But with business rescue proceedings, as the name suggests, the business is being rescued. So through business rescue proceedings, the company is being thrown a lifeline to try and resuscitate it, as it were.
So with commercial leasing and residential in some context, how does it affect a lease agreement when a company enters into business rescue?
So unfortunately, Peter, when a company enters into business rescue, the landlord is not consulted by the tenant. So it's a decision that is made by the tenant directors, as it were. So the landlord will only be notified after the decision has been made and after business rescue proceedings have been commenced that the tenant has been put into business rescue. But there is a small distinction that has to be made in the sense that business rescue proceedings generally apply to juristic persons and, in other words, companies. But there are, of course, instances where business rescue proceedings may apply in the residential space, where a company has leased premises for purposes of residential use.
Now, with the article that we drafted, we specifically set out a timeline, and that timeline goes to 3 months, so 90 days. Can business rescue proceedings be longer than that? Can it be longer than the 3 months time period?
So there is an unfortunate misconception that business rescue proceedings ought to persist or endure for 3 months, but that is practically impossible, because as one could imagine, you have to put a group of creditors together and each one of them wants to get their money back, and you need them to agree to a business rescue plan. So the 3 months really is intended to put together a business rescue plan, but post that there is the more important aspect to it, which is the implementation of the business rescue plan. So as we have seen in the past, in more instances than not, business rescue plan implementation tends to take longer than 3 months. In fact, it goes into months and sometimes into years.
So during the business rescue proceedings, this is always a very big question on the minds of our clients, is the landlord's rights during this process. Yes. So what happens here? Can a landlord cancel a lease agreement? May they evict a tenant from a property? May they issue a summons? So may they actually enforce their rights in terms of the lease agreement should, during the business rescue proceedings, the tenant not pay or something happen and the landlord would like the tenant out?
So the starting point is what the Companies Act says should happen when business rescue proceedings have been instituted. Now, unfortunately, in terms of the Companies Act, there is what we call a moratorium, or rather a general moratorium on legal proceedings once business rescue processes have been instituted. And what that means is no one can sue the company or the tenant that is in business rescue. And of course, as one could imagine where I'm going with this, unfortunately, the landlord is unable to sue the tenant for arrear rental. But there are certain caveats that have been built into the legislation that allows the tenant, the landlord, to pursue legal proceedings. And the first being with the permission of the business rescue practitioner, and number two, with the permission of the court. Now, as one would imagine, it is unlikely that the business rescue practitioner would give you permission to pursue legal proceedings, because legal proceedings means assets and money are going to be attached, which goes against the spirit of the business rescue process. So what is left for the landlord then to do is to approach the court and ask for permission to bring an application. Now, in order for you to do that, one important thing has to happen. The lease agreement has to be cancelled. And naturally, the question that follows is who can cancel the lease agreement? Now, both of them can, and what I mean by that is the landlord can cancel the lease agreement or the tenant can cancel the lease agreement. But under these circumstances, obviously, it will be the business rescue practitioner that does that, because the Companies Act affords the business rescue practitioner a right to suspend certain obligations that accrue to the tenant in terms of the contract. And as one would know, a large chunk of the obligation is to pay rental.
Yes.
So when the business is in trouble, they need money. And the first thing that the business rescue practitioner would want to do is to save and cut corners where they can. And they are more likely to suspend the obligation to pay rent.
Oh, my word. So yeah, a big conundrum when it comes to this. So let's take this a little bit further. So with the cancellation, obviously things need to happen before then. You need to send a letter of demand, etc. So the tenant is now in arrears. They're owing you money. Does the landlord have a secured claim over that rental amount that the tenant might not pay during these proceedings?
So unfortunately not, but the answer is a bit twofold, and I'll explain what I mean by that. Number one, arrear rental does not amount to a secured claim in business rescue proceedings, because as some of our viewers may know, in liquidation proceedings, the landlord is a secured creditor for at least 3 months arrear rental. But with business rescue processes, it's
different.
It's very different, unfortunately. So unless where the landlord has perfected his hypothec prior to entering into business rescue proceedings, then in terms of the Companies Act, that the landlord's right over the assets, that right would have accrued through perfecting the hypothec, remains in place. So the business rescue practitioner cannot do anything to those assets without the permission of the landlord, if, of course, they would have perfected their hypothec prior to entering into business rescue. And what, the silver lining to that as well means, once business rescue processes have commenced, it will be very difficult, if not close to impossible, for a landlord to try and perfect their hypothec.
Taking it a little bit further once again, with sureties
Yes.
on commercial leases, which the majority of our clients or landlords might have, can the landlord still proceed against the sureties on the contract during this process?
Certainly. So the guiding principle should always be remembered is you cannot institute legal proceedings against the tenant or the company that is in business rescue. So everyone else is fair game, because if you go after sureties or guarantors, they are not the tenant, nor are they the person that is in business rescue. So nothing in the Companies Act prevents a landlord, for example, for going after the sureties.
So that's a very good tip for everybody. Remember to sign sureties on commercial contracts.
Yes, of course.
Especially in an instance like this,
Yes.
where it does happen quite often. So can the BR practitioner, the person now in charge of this, take any drastic steps during that time, during the business rescue proceedings, specifically with relation to the lease agreement?
So there are two, as it were, pillars that accrue to the business rescue practitioner as a result of the process. The first being the ability to suspend any obligations that accrue from any contract, and the second being the general moratorium on legal proceedings. And how the two intertwine is, number one, the business rescue practitioner can resist any legal proceedings purely on the basis that there is this moratorium that we spoke about earlier. And number two, they can suspend any obligations that accrue from the lease agreement, and the biggest one being to pay rent. So the biggest drastic or draconian step that any business rescue practitioner can do is to suspend paying rent.
And like you said, the landlord doesn't actually have a say here.
And the landlord doesn't actually have a say, because you would be told after the business rescue proceedings have been initiated.
Thank you so much for that. And last question from my side is, when the business rescue practitioner implements the business rescue plan, does the landlord have a say with regards to that plan? What actually happens to the company during the process?
So as most, like any creditor, the landlord has a say in what happens in the business rescue plan. So the business rescue practitioner would call a meeting of creditors. And at that meeting of creditors, there will be a discussion on the business rescue plan, and there will be a vote on whether the business rescue plan gets adopted or not. Now, the Companies Act makes provision, or it makes it a requirement, that 75% of creditors in value must adopt the business rescue plan. And what that means is your vote will be determined based on how much you are owed as a creditor. So if 75% of all creditors adopt the business rescue plan, and if the landlord, for example, that is not happy with the business rescue plan, and would naturally fall into the 35 or the number that voted against it, if that 75% vote in favor of the business rescue plan, unfortunately the landlord would have no choice but to accept the outcome of the democratic vote, as it were.
Ofentse, thank you so much for that invaluable information today. Michelle, back over to you.
Thanks, Peter. Thanks, Ofentse. That was amazing. Peter, I guess now you're going to come and share with us some of those actual terms that we need to talk about in terms of our documentation, lease agreements, sureties.
Correct, Michelle.
Right. I'm going to hand over to you. Greg, you're going to manage those questions and answers. And remember, folks, in the last 15 minutes, we're going to populate the feedback forms. Do submit those so that we've got some feedback and we know how to make some improvements to these sessions. Thanks, Peter.
Thank you, Michelle. So we're going to go through a little bit of the business rescue terms and conditions in the TPN commercial lease pack specifically. I'm going to pick certain things out for you. We're going to talk about important documentation. At the end of the day, like we said in the interview, surety documents are so incredibly important when it comes to business rescue practice and trying to at least secure rental at the end of the day, not just from the company, but obviously from the third party who signed surety as well. So let's just get into this. Remember, these slides will also be available for you, even though they don't contain a lot of information. At the end of the day, if you would like them, just let us know and we'll pop them through to you as well. You can write that on the feedback form, or you can send it through to the help desk email address or to the legal email address, and we'll be able to assist you with that. Greg, if you wouldn't mind putting up the help desk email address as well as the normal legal email address in the chat already for them, so if they'd like these slides, they can just populate those through. Excellent. So when me and Ofentse spoke about this a little bit, we talked a lot about cancellation rights and specifically how to enforce your rights as the landlord on a property when a tenant enters into business rescue proceedings. And this is so vitally important because just like what Michelle said, timing makes all the difference. When it comes to collections as well, timing makes all the difference. In many of the training sessions I've done previously, we've discussed when to send letters of demand, when to cancel lease agreements. But at the end of the day, that's all up to timing. And with the business rescue plan, or rather process, and yes, the business rescue plan as well, with the article that you're going to be receiving later, just after the session, we're going to actually send you an article that Fullard Mayer Morrison drafted. You'll see that we've created a table specifically setting out the time periods involved in business rescue proceedings. As Ofentse said, it could take obviously longer than the 3-month period, but the table sets out when the meetings of creditors is going to happen, when business rescue needs to be filed, as well as when the business rescue practitioner actually needs to be appointed and when the creditors meetings need to happen for approval of the business rescue plan itself. Now, when it comes to your lease agreement, it is vitally important to know with all commercial contracts, there's not really legislation regulating what you can and cannot have in your contract. It's more based on common law, court decisions, etc., that has happened in the past. So your lease agreement is going to determine and dictate specifically what your cancellation rights are in terms of your lease agreement itself. So you all have your commercial lease agreements. Hopefully it's the TPN one, but we're going to showcase that today to you as well. But have a look at your breach and cancellation clause, because at the end of the day, that is going to determine exactly how cancellation as well as breach in terms of your contract occurs, and whether you can do certain things, specifically cancellation, in instances of a tenant entering into business rescue proceedings. So immediate cancellation versus placing the tenant in breach. Remember what Ofentse said as well regarding the payment of rental when it comes to business rescue proceedings. The business rescue practitioner actually has the authority to suspend certain portions of the contract and obligations in terms of the contract, and those could include rental payments. But obviously, if a business is moving into business rescue itself, there is the very big possibility that they might not even suspend the rental payments, but they just might not make rental payments to you as a result of them obviously being financially distressed. And that's the test that you need to determine if a company or a closed corporation is going to end into business rescue. So there is obviously the possibility of still sending letters of demand should the tenant not make payment to you during the business rescue process or once they've entered into those business rescue. But it's very possible that in terms of your lease agreement, there are also extra cancellation rights that you could utilize in terms of your breach and cancellation clause. And we're going to be showcasing that today in the TPN commercial lease pack. So business rescue cancellation process can go one of two ways. Like I said, you can send the letter of demand should payment not occur, wait the requisite time period that the letter of demand has been stated, or in terms of your lease agreement, and cancel the lease thereafter should payment not be made within that specific time period. Whereas business rescue cancellation could be an immediate process as a result of the tenant actually just entering into business rescue. I'm sure you've seen some of these clauses in your lease agreements. Even in terms of the residential lease agreements, there might be some other terms applicable. So for example, if a tenant is in breach, or if he sequestrates himself specifically, or if something else happens on the lease agreement, then it would be considered a breach. But with commercial contracting, there's a possibility for immediate cancellation in certain instances. Remember also what Ofentse said, there is a moratorium placed on all legal proceedings and enforcement action. And when we talk about that, it's not about the cancellation process. Remember, cancellation and sending letters of demand is not considered enforcement action. Whereas, say for example, applying for eviction or sending out a summons could be considered enforcement action as well as legal proceedings, and thus the moratorium or the statutory moratorium in terms of the Companies Act would apply to those specific actions and processes that you might enter into in terms of your court. So thus, good news, cancellation is allowed. So you can still follow that procedure should the tenant into business rescue proceedings. So let's just head directly into the lease agreement itself. I'm not going to bore you too much today and read this entire section. I just want to show you how the TPN lease, specifically the TPN commercial lease pack, has set out the cancellation processes. And talking a little bit about letters of demand like I've done today, you can already notice that in terms of clause 29.1, it specifically determines the time periods that the letters of demand must be sent. Remember, commercial contracts could also fall under CPA protection, or rather Section 14 of the Consumer Protection Act. and thus there could be 2 time periods applicable here. So you could send a 7-day letter of demand, which is a calendar day letter of demand, or a 20 business day letter of demand as required by Section 14 of the Consumer Protection Act. So you see how we've sort of set that out already in this cancellation clause in terms of the TPN commercial lease pack. So 29.1.1 just deals with the 7-day time period, and 29.1.2 deals specifically with the 20 business day time period. But here's where things start to get a little bit more interesting, because there are certain clauses that you can bring into the lease agreement that allows for immediate cancellation, just like what I said. So let's read through this. Landlord shall be entitled but not obliged to cancel the lease agreement in the event of the tenant being a juristic person committing an act of insolvency, but only in the event that the landlord is also a juristic person. 29.1.4, the tenant filing for business rescue, but only in the event that the landlord is also a juristic person. That's also obviously as a result of CPA protection allowed in that instance. And then 29.1.5, the tenant filing for winding up, but only in the event that the landlord is also a juristic person. So you've got these clauses already included in the breach clause that should an instance occur, that the tenant file at SIPC for business rescue, that you can proceed immediately with cancellation of the lease agreement itself. Remember, there's still the moratorium placed on those legal proceedings, so you might not be able to act further through your attorney to get the tenant evicted, but at least at that point in time, the lease agreement is cancelled, and should the business rescue proceedings end, either by way of the business rescue plan being adopted, or the business plan not being adopted, and the business rescue practitioner actually just ending the business rescue process, it would be possible thereafter to proceed with further legal action through the courts. So you can already see we've set this out in the TPN commercial lease pack to allow for instances of immediate cancellation when a tenant is placed in business rescue. So just getting a little bit further on this, and this is one of the things that I really love to give training on, specifically sureties, because I see this all the time. Greg sees it in practice, Jade sees it in practice. Clients ask us about these questions, specifically about sureties, constantly, on a daily basis, not just on commercial leasing, but also on residential leasing, where the tenant might fall into a category that you're unsure whether they might be able to pay the rental or not. This is obviously a little bit more important when it comes to commercial leasing and commercial contracting, because you're dealing a lot of the time with companies who are leasing the property, or closed corporations leasing the property from the landlord. So surety documents are vitally important. Now, clause 47 of the TPN commercial lease pack, or rather commercial lease agreement, deals specifically with sureties. And there's a couple of things that I'm going to point out to you in the next slide that specifically determines how sureties are supposed to work. But let's just quickly read through clause 47. The tenant undertakes to procure that the landlord be furnished with deeds of suretyship in a format stipulated by or acceptable to the landlord from the natural or juristic person set out in 1.17. Remember, when we're referring to items in terms of our leases, we're referring to the schedule items, those items that are variable in terms of your contract, and you'll be able to input specifically sureties that will be bound by the lease agreement. But wait, this is very important. Just because you've marked on the lease agreement that this person is going to sign a surety or act as surety and be bound by the obligations in terms of the lease agreement, just like what the tenant is, specifically the payments, it does not mean that the tenant, or rather the surety, is actually bound. It is very important to note that a separate document needs to be signed to actually bind that third party, natural person or juristic person, to the actual obligations in terms of the lease. So just merely filling out the item and relying on the contract itself is not going to give you the protection that you require when it comes to your sureties. You need to sign separate documentation. That document is also obviously part of the TPN commercial lease pack, but it's very important to note that when you want to bind a surety, you need to sign a separate document so that surety can be bound to the obligations of the lease agreement, specifically for payment. So it's not automatically part of the lease agreement. You need to elect this, and obviously you need to get those documents signed by the specific third party. Like I said, separate documentation. Very important. Please do this. I see this on a daily basis, that people just go and fill out sureties in terms of the lease agreements and think that these people are bound thereto. They actually not. They need to sign a specific surety document that binds them to that lease obligations. In terms of case law, Investec versus Brains, and like what Ofentse said in that specific interview, sureties can be enforceable during the business rescue process. But this is very important with regards to timing, because it could in an instance be that the business rescue plan is approved by all the creditors and there is some consolidation made and parties have now agreed on a specific amount to be repaid in terms of the rental and ancillary expenses, and those might change the terms of the surety contract itself, because now the tenant is only bound by certain aspects of the lease agreement and making payment on certain aspects of the lease. So timing is very important when you're enforcing your rights for the surety specifically. So what the case law tells us, that it is enforceable during this process. So with regards to the statutory moratorium on legal proceedings and enforcement action on the specific tenant, that is obviously still in place. But when it comes to enforcement action on the sureties, say for example you send them a letter of demand and thereafter a summons, that process can still occur. So you can still try at least to collect money and collect rental and ancillary expenses directly from the sureties during this process. So remember, keep this in mind for all your commercial leasing. It is very, very important that should you in instances feel as if you're a little bit uncomfortable with the tenant itself, being able to pay the rental, or even in instances where you feel, well, this company is really on the cusp, please get those sureties signed. Remember, sureties are also not just the directors of the company. It could be other natural third parties as well as juristic entities that sign surety on behalf of the tenant itself. And like I said, timing is absolutely everything on this. So just quickly before we end off, like I said, I don't want to sell this too much, but at the end of the day, the TPN Commercial Lease Pack does contain all of these provisions as well as these different sets of documentation, including your surety documents, that you can be assured will bind the specific third party to the lease agreements, or rather the obligations in terms of the lease agreements that the tenant needs to make payment of, specifically in that. You can follow this link, the shop.tpn.co.za link. I think Greg's going to post that anyway in the Q&A session right now. He's just given me a thumbs up. That has been done as well. Thank you very much, Greg. And Greg, I think we can end off right over there. That is the formal part of the actual training done. We can move over to the Q&A. I'm sure we've got a lot of questions specifically on business rescue, but you're more than welcome to ask me whatever you'd like during the session as well. Let's use this time productively to get all your questions answered. Greg.
Hi Peter, we have a couple of questions that have come in.
Thanks, Greg.
The first one comes from Anna-Marie and David, and they're both asking if a landlord has a private bond on a property and they battle to pay their bond, can they qualify for business rescue?
Okay, so we've obviously got to differentiate here. I'm not 100% certain if the natural person is a, sorry, they didn't say natural person, they just said landlord. Hey? So obviously business rescue is only applicable to companies and closed corporations. We can all cut off there. So that would create an instance where a natural person can't enter into these proceedings. Regardless of that, yes, it is very possible that any company or closed corporation who is financially distressed can submit application, that specific form, to CIPC to enter into the business rescue proceedings and start the process as such. So it is very possible. Remember, the differentiation here between liquidation and business rescue is one that comes up a lot. It is when a company is financially distressed. There is case law specifically on this in the Wendell versus Marcel Props matter that specifically stated business rescue proceedings is only supposed to be entered into for companies and closed corporations that is chronically ill, not terminally ill. Terminally ill would move you into a liquidation process, whereas chronically ill would move you into the business rescue process. So that test is obviously the financial distress of the company itself.
Excellent. And then we have another question from Janine who asks, if the tenant doesn't move out of the property and at a later date they then move out of business rescue, can you then go back and get the tenant to settle the previous arrears? Oh,
interesting question. So it depends entirely what has happened during the business rescue process, because if the business rescue plan has been approved, there would be some consolidation and there would be some, let's call it, agreement reached between the parties on what should proceed going further. So how things should be paid, how things are not being paid. I'm gauging that this question is if the business rescue process has ended completely and those obligations have ended and the plan has actually not been implemented. And in an instance like that, yes, of course, you've got arrears, you've got arrear rental, you might have arrear utilities, and that enforcement action and subsequent eviction, whatever it might be, can actually be proceeded with at that point in time, yes.
And then we have one final question from Johan, who asks, how would a landlord perfect his hypothek?
Oh, interesting question. Thanks, Greg. That's a lovely one. We usually do this on a residential scope when we talk about this, because as you all know, we've got these things called rent interdict summonses, that within an instance where a tenant does not pay rental, the landlord can send out a summons specifically, and the tenant and the sheriff can actually attach the goods of the tenant through that specific process, through that rent interdict summons. When it comes to commercial leasing specifically and residential leasing, perfection of the hypothek is vitally important. And there's only two ways to perfect a hypothek in terms of law. That is specifically sheriff attachment, so sheriff attachment of the actual goods in the premises, or a court order determining that. We always say this, it's very important. You've all got these clauses in your lease agreement that talks to a tacit hypothek in terms of your lease agreement, but that tacit hypothek is not enforceable. So even if the tenant removes goods from the premises, if they be in arrears, they cannot be held criminally liable, and they cannot actually be held liable for that because the hypothek has not yet been perfected. It's only when the hypothek is perfected that you can enforce that criminal action or the legal action should it occur if the tenant removes the goods. And once again, those two things are attachment by the sheriff as well as a court order specifically attaching those goods. Greg, is that us for today?
That's us.
Can you believe it? No more questions on business rescue. Guys, if you do have any further questions, you're more than welcome to contact us. Remember, you can contact the help desk line. Greg's put up those details, as well as the legal eagles at TPN, who will be able to assist you with further questions. But for me, for us, for today, thank you so much for joining us. Have a great day further.